Today we'll be briefly going through the case Indian Ex-servicemen movement and others versus Union of India and others. It is also called the One Rank One Pension Scheme, in short OROP scheme. The Supreme Court on 16 March 2022 upheld the centre's OROP scheme for the armed forces. Before looking more into the judgment, let's first go through the history of the OROP scheme in short. In 2015, the government had announced about the implementation of the OROP scheme for the armed forces, but the veterans were dissatisfied with the policies in this scheme. So, a group of former servicemen under the banner of the Indian Ex-servicemen movement filed a petition challenging the centre's November 7, 2015's notification, which announced equal pension to military personnel retiring in the same rank with the same length of service regardless of the date of their retirement. In the petition, the petitioners complained that the pensioners of the same rank who were a homogeneous class were arbitrarily being given varying pensions under the OROP scheme. They stated that this defeated the purpose of the policy, as there are different grades of pensions for veterans who retired under the same rank. The court denied the argument and stated that all pensioners who hold the same rank may not, for all purposes, form a homogeneous class. For example, among Sipais, differences do exist because of the MACP and ACP schemes. Certain Sipais do receive the pay of higher rank personnel. Here, the court indicated that there is no legal mandate that same rank pensioners must be given the same pension. As certain servicemen will be subjected to different pay scale grants, their pensions also get deferred. So, variation does occur while paying the pensions to such servicemen, and therefore, according to the court, this variation is justifiable. The petition also sought implementation of OROP as recommended by the Bhagat Singh Koshyari Committee, and that the pensions of the veterans should be automatically revised every year instead of the current model that is based on a review once in 5 years. To this, the court stated that the manner and the period over which revisions of pensions, salaries, and other financial benefits take place is a pure question of policy. Therefore, the decision of the central government to revise the pension every 5 years is a question of policy and thereby nowhere violates the pensioners' right to equality. Thus, the court held that it finds no constitutional infirmity in the OROP principle as defined in the 2015's notification of the government regarding the implementation of the pension scheme. Further, the bench directed the government to refix the pension from July 1, 2019 and to pay all the arrears within a period of 3 months. So that was about the OROP scheme case. Remember to subscribe to stay in tune with more such legal updates, and I'll meet you in the next video.